This is week 5, and we'll finish up on the 7 levels of hostility that we discussed the previous week, and then we'll begin a new topic, Japanese immigration to the U.S., which would include a discussion of the historical context of Japanese immigration, some of the immigration characteristics, and also how did the Japanese learned from the Chinese experience? Were they able to avoid the situation that the Chinese fell into? With regards to the 7 levels of hostility that we introduced last week, which includes prejudice, prejudicial ideas, economic discrimination, political disenfranchisement, physical violence, immigration exclusion, social segregation, and incarceration in mass. We'll continue with our discussion. I believe we left off at immigration exclusion. The 5th level of hostility against the Chinese was immigration exclusion. This included the Page Law of 1875, the Chinese Exclusion Act of 1882, the Scott Act of 1888, the Gary Act of 1892, the extension of the Chinese Exclusion Act in 1902, and in 1904, Chinese exclusion becomes permanent. An act to prevent the coming of Chinese laborers to the United States. This was in the preamble of the Chinese Exclusion Act of 1882. This was the first piece of legislation in the United States where a particular national group was actually named and targeted for exclusion. An act to prevent the coming of Chinese laborers to this country. The only one barred out, a political cartoon that was somewhat sympathetic to the Chinese at that time. It states, the only one barred out, enlightened American statesman, quote, "We must draw the line somewhere, you know." The Gary Act of 1892, in their preamble, it doesn't just say laborers, but it says an act to prohibit the coming of Chinese persons into the United States. Under the Gary Act, exclusion was extended for another 10 years. There were restrictions on all Chinese in the U.S. There was an identification card system requirement, and there were mass roundups on the streets to demand identification cards from any Chinese person who was out and about. Okay. Habeas corpus rights were denied. People could not go to court to prove that they were here legally. They were rounded up, demanded the identification cards, and if they did not have these identification cards, they could be deported. They would have to prove that they were here legally. The 6th level of hostility is social segregation. Chinese were forcibly removed from the rural areas into the urban Chinatowns, where they were socially isolated. There were also fears of contamination. Chinese children were not allowed to attend white schools. Tate versus Hurley was a superior court case in the city of San Francisco affecting 8-year-old Mamie Tate, who was denied entry to Spring Valley School by the principal, Jenny Hurley. There was a new California political code that was passed in 1880 requiring education access to all children between the ages of 6 to 21 years. Mamie Tape's family filed a lawsuit against the San Francisco Unified School District in 1884. The Tape family argued that they were assimilated, they wore Western style clothing, they practiced Christianity. The Superior Court actually ordered the admission of Mamie Tape to Spring Valley School. In response, the school officials established a separate Oriental school for Chinese, Koreans, and Japanese to keep the races, the Asians, separated from the white race. This separation was facilitated by the passage of State Assembly Bill 268, which lasted between 1885 to 1947. AB 268 established separate schools for children of Mongolian or Chinese descent. When such separate schools are established, Chinese or Mongolian children will not be admitted into any other schools. The passage of AB 268 and the establishment of the inferior Oriental schools led Mamie Tape's mother to write a letter to the school board in 1885. She wrote, "Dear sirs, will you please tell me, is it a disgrace to be born a Chinese? What right have you to bar my children out of the school because she is a Chinese descendant? There is no other worldly reason that you could keep her out, except that of she charged discrimination." Mary Tape's letter to the school board is an example of public discourse as an example of resistance. Even though the Oriental schools have now been established, including ones in Oakland, as well as San Francisco and other areas, Mamie Tape's mother, Mary Tape, felt that it was important to speak out. The fact that she wrote this public letter gives us documentation of what that generation did to fight for their rights. Incarceration is the highest form of anti-Asian hostility. This happened in 1910 to 1940 with the operations at Angel Island Immigration Station. 1942 to 1945, Japanese Americans were placed in concentration camps during World War II. And in 1950, the McCarran Internal Security Act was passed, which had within it emergency detention statutes, which gave the president the power to detain individuals who may conduct espionage or sabotage. And this was during the Cold War, when there was a lot of attention and focus on Chinese in America. The Mamie Tape case and the mother's letter to the school board is an example of resistance. There were many other examples of resistance to hostilities. This included self-defense, the hiring of security guards to protect the community, the hiring of skilled white attorneys. This was actually the most popular way that resistance took place, where they demanded constitutional rights. But, however, successes were limited to civil rights within the boundaries of the United States, but not immigration rights that had to do with access from out of the country and into the United States. Public statements were made, and also international appeal, asking people to, let's say, boycott American goods because of what was happening to Asians in America. There was legal resistance against the Chinese exclusion laws, in particular the Scott Act, which denied re-entry rights for Chinese aliens within the boundaries of the United States. 1889, Chen Chai-ping versus the U.S. This was a re-entry case that challenged the Scott Act of 1888 because of the fact that Chen Chai-ping was a laborer and he was not a U.S. Citizen. The federal government, according to the U.S. Supreme Court, had the absolute right to exclude if necessary for national security interests. 1898, a similar case with Wong Kim Ark, a Supreme Court case that took place, Wong Kim Ark versus the U.S. It was a re-entry case, but because of the fact that Wong Kim Ark was born on U.S. soil, he was a U.S. citizen, and he was therefore protected by U.S. law, so he had the right to re-enter. The 14th Amendment allows for birthright citizenship, and he was a citizen by birth. Just solis, birthright, overrides just sanguinis by blood or ancestral connection. So because of Wong Kim Ark's U.S. Supreme Court victory of 1898, everyone who is born on U.S. soil has birthright citizenship. Under the 14th Amendment of the U.S. Constitution, all persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the U.S. and of the state wherein they reside. In 1901, Wong Kim Ark was actually working in El Paso, Texas as a cook, and he was arrested by an immigration officer named Charles Meehan, who was nicknamed the Chinese Capturer. He's known for rounding up Chinese. And even though Meehan knew that Wong Kim Ark was a U.S. citizen, he still arrested him, and Wong Kim Ark was held in jail for a 3-month period. In 1910, Wong Kim Ark was not aware that his son Wong Yok-fun was trying to enter the United States, and Wong Yok-fun was detained and later deported from Angel Island Immigration Station. If Wong Kim Ark was aware and had the information, he could have been there to arrange for his Wong Yok-fun's release. The birthright citizenship is threatened today. President Trump signed an executive order to ban it, and is currently going through the courts. Another young man, a Chinese laborer, an alien, took up a challenge to the Gary Law in the Fong Yue-ting case of 1893 versus the Gary Act versus United States. He was charged with violation of the Gary Law in 1892. He didn't have the certificate of residency, and he refused to be deported. Under the Gary Law, there was a requirement that people hold a certificate of residency, which included a photograph. And if they did not have that, the Chinese person accused would have to come up with 2 white witnesses to prove that they were here legally before the passage of the exclusion laws. He had only Chinese witnesses. He did not have any white witnesses. It was common at that time for Chinese to be rounded up, and Fong Yue-ting did not win his case. The court ruled that the U.S. had sovereign right to deport citizens for the sake of national security. In the case of Yik Wo versus Hopkins, uh, this was a class action suit against the San Francisco Board of Supervisors. There was a law that required that all laundries in the city of San Francisco that were made out of wood required a special permit from the fire department. 310 laundries in the city of San Francisco were made out of wood. All 240 Chinese laundries were not allowed permits. The rest of the laundries were white owned and they were allowed permits. So Yik Wo, one of the laundries, took this case all the way up to the U.S. Supreme Court as part of a class action suit against the San Francisco Board of Supervisors. Hopkins was the sheriff who implemented the Board of Supervisor decision. So the Yik Wo laundry won. The Supreme Court ruled that a law which appears neutral but is applied in a discriminatory manner is unconstitutional under the 14th Amendment. Under the 14th Amendment, all persons shall be treated equally under the law. It states all persons, it doesn't say citizens, but it said all persons, and they were able to zoom in on that section. So there was a difference between legal resistance with regards to immigration rights and legal resistance with regards to civil rights within the United States. Within the boundaries of the United States, they would often find victories, okay, because of the 14th Amendment. But with regards to immigration rights, the successes were not as good. Okay. Resistance also took other forms, minor lookout systems, labor strikes, boycotts, discourse, writing counter arguments. Wang Qin-fu, who was born in 1847, passed away in 1898, coined the term Chinese American. He was a self-proclaimed Chinese first missionary to the United States. He offered a $500 award to anyone who can prove that the Chinese ate rats. He challenged Dennis Kearney, the head of the Working Men's Party, to a debate and a duel. He founded the Chinese Equal Rights League to oppose the Gary Act of 1892. An outspoken person, he argued that he was both assimilationist and a Chinese nationalist. He stated that only character and fitness should be the requirement of all who are desirous of becoming citizens of the American Republic. He argued for assimilationism. He introduced the term Chinese American, but also he was concerned about change in China, stating that U.S. missionaries were misreporting on China, and this led to negative stereotyping of the Chinese. Previously, with regards to treatment of the Chinese in America, there was heavy reliance on homeland government to negotiate with the United States. This included the passage of the Burlingame Treaty of 1868. There were appeals to the consulate office. These were found to be weak and ineffective, and other avenues were sought, both legal and as well as accommodative types of resistance. It was an uneven battle. There were victories related to 14th Amendment protections, but there were many defeats with regards to immigration policy, where the Supreme Court upheld the right of the U.S. government to discriminate along basis of nationality. So it was an uphill battle with victories, um, fighting for civil rights in the cases of the Tate family, in the cases of the Wool laundry. Um, but there were many defeats with regards to immigrant rights, and we'll see how the next group, immigrating group, fares. The Japanese immigrants who followed afterwards.